My name is Lisa Woodard. Griswold and Roe were correctly decided, but Casey was not. In Griswold v. Connecticut, I agree that although the right to privacy in marriage is a right so firmly rooted in tradition that its protection is mandated by various constitutional amendments, I put forth two additional concurring concepts why the ruling in Griswold was correctly decided. Number one, a reasonable person can assume the legislative intent behind the statute was religiously motivated and perhaps reflected the religious beliefs of certain puritanical legislators. This statute therefore ran afoul of the free exercise clause of the First Amendment, as it forced individuals to adopt those similar religious beliefs, as well as prevented them from the free exercise of their own religious belief that contraception was acceptable. Number two, legislative powers. My focus is not only on the couple's ability to keep the government out of its bedroom, but rather a lack of standing where and how the government was empowered by the people to knock on the bedroom door in the first place. In the U.S., a couple's decision to not have a child should be just as far removed as any governmental authority dictating how many children they should have. In Roe v. Wade, I agree they got it right because, number one, the precedent in Griswold protected the decision whether or not to bear a child. Termination of an unwanted pregnancy falls right in line with the choice to not bear a child. This liberty is protected by the Due Process Clause or an enumerated right protected by the Ninth Amendment. The right to an abortion should be recognized as a fundamental right triggering strict scrutiny because of the great impact childbearing and childbirth has on a woman's life. The Texas law failed strict scrutiny and was not supported by a compelling state interest. Interest in protecting fetal life is not compelling because fetuses have no rights under Texas law, nor within the Constitution. An interest in preventing promiscuity is not closely tailored to this law, and an interest in protecting a mother's health does not justify a total ban, only regulation to increase the safety of the procedure. As a 15-year-old rape victim just 7 years after Roe, I feel grateful the government did not have the ability to limit such a personal and private decision I might have had to make. This leads me to my belief the decision in Planned Parenthood v. Casey was partially right and partially wrong. I agree spousal notification is unduly burdensome and unconstitutional. I also agree states may outlaw abortions of viable fetuses, although today a 22-week-old fetus has a 10% survival rate. I disagree the 24-hour waiting period was not an undue burden. It has become so today, as a handful of states have only one abortion clinic, and overnight travel does teeter on an undue burden. I most vehemently disagree, though, requiring parental notification in the case of minors is constitutional. There are many reasons parental notification does present an undue burden that places a substantial obstacle in the path of a woman, albeit young's, fundamental right to choose. Although everyone hopes that teens can turn to their parents when faced with an unintended pregnancy, and in fact most teens do, laws preventing teens from obtaining health care unless they can talk to a parent put their health and safety at risk and do not increase family communication. Consider that teens who do not involve a parent may have very good reasons for not doing so. Notification may exacerbate an already volatile or dysfunctional family situation. Today, just 16 of the 39 states with parental involvement laws provide exceptions for minors who are victims of sexual or physical assault, incest, or neglect. As the New Jersey Supreme Court found when it held that states' parental notice law unconstitutional in Planned Parenthood v. Farmer, a law cannot transform a household with poor lines of communication into a paradigm of the perfect American family. But forcing young women who cannot turn to their parents to go to court is unrealistic and can create substantial delays. Teens are already more likely than older women to have later abortions, and restricting teens' access to abortion only causes further delays and medical risk. And parental involvement laws also disproportionately affect young women of color, who are more likely to experience unwanted pregnancy as minors and are disproportionately living in states where parental involvement laws are in effect. These laws also unfairly single out pregnant teens who choose abortion. If teenagers can consent on their own to services related to childbirth and even to delivery by C-section, there could be no health-related reason for denying them the right to consent to their own abortion. Legislation which seeks to protect The women's right access to abortion must include younger women and protect their access to safe, legal, and affordable care.